Consider the following scenario. An 83-year-old woman is receiving hospice care at home, nearing the end of her life. Her husband of 15 years, a military veteran, is currently in a rehabilitation facility following the implantation of a pacemaker. Their son holds durable power of attorney, medical power of attorney, and HIPAA authorizations. However, there is no trust or will in place. The woman remains mentally competent, which takes precedence over her son's legal documentation. As they are legally married and reside in a community property state, her wishes must be respected. She has chosen to remain in her home until death and declines an end-of-life lease, although she may not fully grasp its implications. The husband is designated as the beneficiary, but since he is institutionalized, the son is responsible for determining whether to retain or sell the house. What steps should be taken in this situation? Here's the answer. This is a tough but very real scenario, and it blends estate planning, property law, and family decision-making. Let me break it down step by step in plain English, so it's clear what's really happening. 1. Her wishes still rule. Sound mind supersedes POAs. Because the 83-year-old mother is still of sound mind, her durable power of attorney and medical POA don't apply yet. Those only activate when she's no longer capable of making decisions. As long as she's competent, her wishes are legally binding, even if the son has all the paperwork. 2. Community property complications. Since it's a community property state and she's legally married, the husband is automatically the primary heir-dar beneficiary of her portion of the estate, including the house. Even if the trust and will are in place, her current wishes matter, and her spouse's rights can't just be ignored. 3. The end-of-life lease question. She's refusing an end-of-life lease because she wants to die in her house. What she may not understand is that dying at home without shifting control means the house remains tied up in her name, plus her husband's name. Nothing can be sold, refinanced, or leased until she passes, and ownership is legally transferred to the surviving spouse or trust. So the son cannot override this yet. He can only step in after she loses capacity or after she passes. 4. The husband's situation. The husband, currently in rehab, is the beneficiary and will legally inherit her share of the house. But since he's not in a position to manage things, the son's authority as POA will kick in for him once she passes. That's when the son must decide whether to keep or sell the home. 5. What the son can do right now. Respect her current wishes. While she is mentally competent, nothing overrides her right to decide, even if it feels impractical. Prepare documents. Ensure the trust and will are properly updated and the property is actually titled into the trust. This is the #1 mistake people make. Plan for transition. Once she passes, title automatically shifts to the husband as survivor in a community property state. Then the son, as POA, can act on behalf of his father, either keeping or selling the house. 6. What happens if nothing is done? If the trust isn't funded, house isn't titled into it, the estate may still go through probate. If POA documents aren't fully recognized by institutions, there may be delays in paying bills or accessing accounts. Family disputes could arise if beneficiaries aren't crystal clear in the trust, will. Bottom line, right now, the son cannot override his mother's wishes because she's competent. Once she passes, the husband inherits, community property laws, and the son can then act as POA for his father. The smartest move is to double-check that the house is in the trust, all POAs are current, and everyone understands that the son's authority truly begins once capacity is lost or after death.